Thank you all so much for tuning in to another exciting episode of Talking Retirement. We just had Kim on the podcast about a week ago to talk about Ocean County Senior Services, of which she is a board member. And now she gets to be the undivided star of the show, where she gets to talk about her specialty, which is estate law. She is one of the coolest voices in New Jersey for all these topics, so we're very excited. Kim, how are you doing today?
Great. Thank you so much for having me. I'm really excited to be back.
Yeah, so we always like to start off a little bit about you. We didn't get to last time. So how did you end up being in estate and elder law?
When I got admitted to practice, my first place of employment was with legal services, and I was an attorney with, at the time it was Ocean Monmouth Legal Services, and then they wound up changing their title at some point in the future. But I worked for legal services for 12 years. And as a legal services attorney, you have certain things that you deal with on a daily basis. So all of our clients were either low income or seniors or disabled, because you had to meet a certain financial criteria to be eligible for legal services. And we received state and federal funding to provide free services to eligible persons in Monmouth and Ocean County. And so we had to deal with crisis situations all the time. And our priorities were really focused on preservation of income, preservation of housing, preservation of other benefits. And when you do that day in and day out for a number of years, your focus is always on the person and their needs and being able to identify their needs. And so we always had a lot of seniors in the office, because very often, even though seniors receive Social Security, if you don't receive a pension, if you don't receive any other additional monies, you really have limited income, and there's a lot of seniors in the area that really couldn't afford a private attorney. So I was used to dealing with seniors on a daily basis. And after leaving legal services, then I transitioned to a private firm in Freehold, and that's actually one of the partners there was specialized in estate planning and elder law. And so I started learning certain aspects of estate planning and elder law from him and his staff. And I really enjoyed it, and I really wanted to make that an area of expertise for myself. And so I decided that I wanted to work someplace and work with somebody that just focused solely on estate planning and elder law, because there's so much to learn under that umbrella that it was hard for me to do that when I was doing all these other things at this other firm. Since working with, so I've been with the Timothy Rice Estate and Elder Law firm since 2019. Tim was a sole practitioner. I am a partner with the firm now, and Tim specializes in just that. The main office of the firm is located in Voorhees, New Jersey, but we do have a Freehold location, and I have mostly built my client base and my referral sources from Ocean and Monmouth County. I live on the border of Monmouth County. I'm actually live in Ocean County, but I'm right on the border of Howell, Jackson. And so, I wanted to broaden the client base of the firm, which was predominantly in like Camden, Burlington, Gloucester area. And so we've now been able to broaden our services, which is what I've been able to bring to the table, to include counties like Monmouth, Ocean, and Middlesex, and provide services to that pretty broad range of the central, southern type area of New Jersey. So I'm really excited about that.
I think one of the most interesting things about Ocean County, and even people in Ocean County don't realize there is such a huge senior population. I remember we had some friends visit our office, and they were like, I had no idea there were all these retirement homes back here. It's massive. Your firm is obviously helping these people. What are some of the common issues people are facing in Ocean County as seniors? You mentioned the income insecurity, but what are some other things that they're dealing with?
Well, we have to remember that seniors vary greatly depending on age, depending on resources, right? So you can have a very affluent, active, healthy 85-year-old that still drives and has a lot of family and is really able, is self-sufficient, independent, able to take care of themselves, have family that can help them if they ever needed help, know how to use a smartphone, a computer, drives, all of these things, right? You can have another 85-year-old that suffers from severe health conditions, lives alone, maybe doesn't have any family in the area or just a few friends, but no one really that they could rely on, limited income, doesn't drive, okay? So that same 85-year-old is a completely different story. And so you kind of have to take your clients as they are, and you have to identify different challenges that they face. So the first example is going to have a very different conversation with me. We might be talking about, they might have questions about Medicaid planning and asset protection. They might have questions about, they might want to update their estate plan. They might have some other issues that might be concerning them that the second type of individual doesn't have those issues. They have a whole slew of other issues. They might need a lot of resources, in-house support, for lack of a better word, support to keep them in their home. Maybe they won't be able to stay home, and becoming eligible for Medicaid is something that's more likely going to happen for them because they don't have long-term care insurance. They don't have anyone to assist them in the home. They are lower income. They have a bunch of health problems that might render them finding the need for long-term care. So it's going to be two completely different conversations. So you have to always remember it's not cookie cutter. No client really is cookie cutter. You have to really pay attention. You have to ask questions. We ask a lot of questions. I'm sure you do too in your line of work. We have like a 9-page questionnaire, which people really don't want to fill out at the time. But I assure you, to all the clients out there, I assure you we're not just making work for you. It's important because all of those things, your family, your health, your income, that all goes into play when I am assessing your needs. And there might be things that you don't think to ask because you don't have the information to know to ask, right? So it's my job to be able to provide you with as much legal advice and information and referrals. I make referrals a lot of times to community advocates and other persons in the community that can provide services that we don't provide. Those are the things we have to just make sure we listen and pay attention and kind of give a holistic approach to their needs.
So something that's very top of mind for me today, Kim, is right before we recorded the podcast, one of my clients called. Their spouse is going through a severe medical issue. They're trying to deal with Social Security to get Medicare. No power of attorney, no medical directive. I feel like estate planning is one of those things, or elder law or whatever it might be, is one of those things where people say, I'll get to it, I'll get to it, I'll get to it. And then when something hits you, you realize that you really should have had everything in place years ago. Can you speak to the urgency that people need to approach this subject with? Because like I said, people think it's 10 years down the line, but you never know when something's going to happen.
So we stress the importance of having a power of attorney and a medical directive as soon as you are an adult, as soon as you're 18. And no one really thinks about that. And we were putting out blogs and posts about your adult children in college, because you think of college age kids as still kids, right? We don't really always think about them as adults, but they are adults. And if something happens to your college age child when they're away at school and they become incapacitated, you don't, as a parent, being a parent doesn't give you legal authority to handle their banking or to make certain decisions for them. As young as 18, 19, 20, we're encouraging people to get a power of attorney and get a medical directive. Certainly as an adult, if you might have several bank accounts, a house, a business, all these things can be happening in your life. And if that scenario were to happen where you get into an accident, you become sick, and you're not able to handle your finances, who's going to do that for you? Your spouse doesn't have the ability to do that just because they're a spouse. A parent doesn't have the ability to do it just because they're a parent. If you have somebody joint on one of your bank accounts, that's a different story. A joint bank account owner can handle those things. But other than that, there's many instances where you have situations and relationships where someone might kind of be the primary person to handle finances. Not all couples, not all persons have joint assets. There are a lot of single persons, single individuals or unmarried individuals who have a lot of assets in their own name. And without designating someone to step in if something were to happen to you, it becomes a big problem, right? So what's the problem? If you don't have a properly executed power of attorney where you can authorize someone to make decisions for you, then you might have to go the route, if you become incapacitated, then you might have to go the route of a guardianship action. And I'm going to save you that'll be a conversation for another day, but it's time consuming. It's a formal legal process. You have to go in front of a judge. You have to get two independent physicians to say that you lack the capacity to manage your affairs. And so it becomes a much more difficult process than if you just had that one piece of paper. A medical directive is similar to a power of attorney in the sense that you're appointing someone to make decisions for you, but medical directives focus on medical decisions and particularly end-of-life treatment, and whether you want to withhold end-of-life treatment or you want, the physicians to take every precaution to extend your life. So these are really hard things to think about. It's not, it's not fun to talk about these things or to think about these things, but it's really important because I have seen on one too many occasions family members frantic that dad now has dementia and he had all of his accounts in his name and he's in a long-term care facility and there's no way to pay the facility from dad's money because none of the kids have access to dad's money. And so now we've got to run into court to try to get the guardianship process going so that someone has authority to manage his affairs. So a very simple document saves all of that headache and trouble for your loved ones.
I think that's a pretty good segue to the next thing I want to talk about is you as a parent might assume that, oh, my kid's at college. If something happens, I can make medical decisions for them. You might assume as a child that, oh, I'll have access to my dad's bank accounts. There's a lot of myths around this elder law space, around this estate law space. I know you guys have the 7 big myths that you want people to avoid. Can you touch on some of the myths that you guys have been trying to get out there and try to answer so people know that they have to get ahead of this and really take care of it as soon as possible?
So if you have a power of attorney, if you have a medical directive and a will, I think people let them just sit there, and they sit there for what winds up being decades. I have people that come into me with wills from the 80s when their children were little children, and now their children are adults with their own children. So the whole scope of your plan is going to change at that point. I certainly don't think you need to update your will every, 3 to 5 years unless something happens in your life that is a major change, right? So the death of a spouse, the death of a child, a major health issue that may or may not change the scope of your estate plan. Certainly any changes in the law. So there's been no estate tax. I think estate tax in New Jersey has been phased out since 2018. And so, any clients of ours, we would certainly send out a mass mailing, a mass email to all clients to let them know if there are any legal changes. But these are all things that would prompt somebody to change an estate plan. Absent that, we just look at time. Time changes things for you. people that you might have someone that you might have appointed as your executor, maybe you don't have a relationship with that person anymore. You don't even talk to that person anymore. So something as simple as that. So it's always a good idea, I'd say, at least every 5 to 7 or 7 years, take a look at the documents, make sure that your intentions are still there, and if you think they need updates, come in and see someone like me and we could talk about, what types of updates you might need. And sometimes, unfortunately, you just have someone that prepared documents that wasn't really an expert, and something as simple as, well, I have a will that I signed and it's notarized. Okay, but the law now requires that you have 2 independent witnesses. So it has to be 2 persons to witness, a notary, and your signature. So something as simple as that. Or something as simple as, well, I have a will, it's notarized, signed, it meets all of that, but maybe you only have 1 named executor. And what if something happens to that person, if they get sick or they pass away and you don't have a successor named? That can cause a problem at the time that you pass away, and now there's no one named. The person that you named is deceased. So now what happens? So little things like that a lot of times it's not on someone's radar, but it's something that I know to look for and to discuss with the client as far as updates are concerned.
Yeah, thank you for the very comprehensive answer. It's amazing how many little things add up to such a massive, intense conversation. And something I want to talk about something I do want to talk to you about is the conversation. So me and my parents recently, and I think it's something everybody should do, you have a conversation about where the documents are, what assets you have, what's your plan for the next 5-10 years. Do you encourage your clients to have family members come in and talk to you as well? Like, how do you factor communication into these conversations with your clients?
So you have to factor it in carefully, because as much as I would like to sit here and say that all families are great and everybody gets along and there's never going to be any problems, we all know that doesn't exist, right? So you have to be reasonable. And you kind of have to be aware of your complete surroundings. So what I mean by that is, if I have someone come in to me and they want to talk about updating their estate plan, it's very often they come in with an adult child, okay? They just might want the comfort of bringing somebody. They might not drive and they just want their son or daughter to drive them, whatever it may be. I always ask them and make sure that it's okay to have this discussion in the room with their child or whoever the person may be. And then we start the conversation. Now, if I start hearing things about, I want to disinherit this one and this one, and I want to leave everything to the person that's sitting in the room right now with me, well, then I might ask that person to step out of the room at some point, and I'm going to have a private conversation with the client as to why they want to do that, right? Because the last thing that I want is to I don't want my will to be the subject of a will contest that's going to be heavily litigated at some point. So I have to certainly protect myself, my reputation, and my client to make sure that there's no fraud, duress, undue influence that's happening over this person. So you have to be really, really careful as an attorney what you're doing. But usually, that doesn't usually happen. That's certainly an extreme case. But you obviously have to do things just to protect yourself, to protect the client. But overall, you can have those conversations in front of family under the right circumstances. And sometimes I have them all there. The client has 5 kids, and I got 3 in the room with me, 1 on Zoom, 1 on the phone, and everybody wants to hear what's going on. And that's great, because then you know that, everybody's sort of on the same page. Everybody understands what's happening, and that's fine with me. The more the merrier.
No, it's awesome to hear. I mean, like you said, it can be weird. You get, I'm sure varying personalities and people butting heads about little things. Kind of piggybacking off that, What does it look like on your end? Because you obviously see the end product. You see what happens when that person is in the hospital in a nursing home, and then after, when the estate is getting divided. What does a good estate plan look like on the other side versus someone who didn't properly plan? So what I'm trying to say concisely is, what is like the best case scenario? Obviously nothing's perfect, versus like a very bad scenario if you don't plan ahead.
So I think the best case scenario would be the person you name as your executor is alive and able to serve as executor. They go, they get appointed. They have to then analyze, basically they have to administer the estate. So they have to analyze whether there's any debts, taxes of the estate, administrative costs. And then ultimately, right at the end of the day, you're going to make distributions to everybody who's named in the will. And if you could do that and nobody fights and everybody's happy and you get that estate administered, we're good, right? So that's the best case scenario. Everybody's happy, everybody gets it, it goes through pretty smooth. On the other hand, something as simple as, like I said, I'm going to just touch on this example. The example which I gave earlier, which is, what if I name only one executor and no successors, okay? And I'm going to just make up a story. So I pass away and I have 3 kids. And let's just say I name my oldest son, Bob, as my executor, and I don't name anybody else. So when I pass away, at the time I die, let's just say Bob predeceased me, okay? So now I pass away and my child Bob is no longer alive. So now I have 2 other children. Well, first, none of them are named as executor, as a successor. So somebody would have to step up and apply to the surrogates, the county surrogate, to become my, at that point you would actually call them an administrator. It's a technical change of language, but it's basically the same thing. One of them would have to apply. Now, what if both of them want it? Or one thinks that he shouldn't do it because he's bad with money. Well, she shouldn't do it because she's an alcoholic and doesn't know anything and doesn't know what to do. So now you have 2 siblings that are fighting over who should handle the administration of the estate. P.S. If they don't agree and they can't agree, now you have to go to court just to probate the will and get somebody appointed. We haven't even started with the administration of the estate. And if you have 2 persons that are contentious, they can't communicate, it's only going to spell out disaster to get anything accomplished. So a small problem can be a big problem. And then before we even get our foot in the door of getting somebody appointed. So the plan really, you really have to make sure that you're kind of covering all bases. You can't make an estate plan that goes to infinity, right? But we also have to sort of take into account, 2 generations beyond your client. So, for example, if you have a client that has children and grandchildren, you might want to make sure that the language says, well, if upon my death my child were to predecease me, where do you want that child's share to go? Do you want that child's share to go to your grandchild, or you want that child's share to go to your living children? If you say, well, I want it to go to my grandchildren, well, what if you have minor grandchildren? Well, you need to then put a provision in the will to protect the minor grandchild so that you can't give a 16-year-old an inheritance, right? They're not an adult. So you have to put a provision that a trust can be created to protect any minor beneficiary. So you have to think in layers. You have to think about multiple scenarios. And that's certainly one thing that I have a lot of clients say to me. It's like, I didn't even think about that. You come in with things that you want to talk about, and then you start talking, and then they look at me and they go, wow, I didn't even think about that. So it's, anticipating the unexpected, without overly complicating the estate plan. Those are kind of the goals. We want to make sure, because I've seen estate plans that look like books. People come in with binders of multiple pages, multiple powers of attorney, trusts that are so complicated, I have to read them 6 times before I can even understand them. You can't expect a lay person to even know what to do. And so you want to make it as clear and as simple as possible while simultaneously accomplishing what needs to be accomplished, and also taking into consideration we have to anticipate the unexpected. So having said all of that, I don't really know if I even answered the question, but I think I did. It's a mouthful.
No, I think it just goes to show how complicated all this is. And I guess just bare bones, I think the thing I've heard is really need to focus on will, power of attorney, and medical directive. That's kind of like the most pressing thing before you get started, right?
Yes. And then, trust is a hot topic. I mean, you and I could probably talk about trust for a whole nother hour, but that's actually another myth. I have people coming into the office all the time. I need a trust. Well, who told you that? Why do you think you need a trust? I don't know. I was just talking to this person and this person said you need a trust. So in New Jersey, we kind of look at trusts as a needs-based thing. Okay. One of the first myths are you need a trust to avoid probate. Well, we don't really need to avoid the probate process in New Jersey. Unlike other states, it's not very expensive and it's not really very difficult as long as you have all the things you need to get yourself appointed. Where, as I had illustrated earlier, where it can become complicated is in the administration of the estate, right? That's where it gets complicated. And having all your assets in a trust doesn't necessarily make the process simpler. You still have a trustee that has to get appointed. You still have a trust document that supposedly should explain what you need to do with the trust assets. And if the trustee can't serve or doesn't want to serve or doesn't know how to be a trustee or doesn't understand the trust, you're going to have the same problems. You're going to have problems with the administration of the trust. So just taking all your assets and dumping them in a trust isn't necessarily going to solve any problems, okay? So, we also have to look at, some of the other things. Do you have a disabled beneficiary? Maybe we need to do trust planning to protect a disabled adult disabled child that's receiving Social Security and Medicaid. There's certain trust planning that we can do for that. Maybe you have adult child who's just a spendthrift that you don't really trust will be fiscally responsible with the inheritance. So maybe we want to discuss a trust for that reason. So again, it goes back to my questionnaire and why I ask a lot of questions, because I'm trying to ascertain the information I need to make a good recommendation. Higher net worth clients might be a reason to do a trust for, federal tax implications, federal state tax implications. So there's a million and one reasons why one would do a trust, but there's also a million and one reasons why everybody doesn't need a trust. So we have to look at each situation, we have to look at each client individually and make a determination what's the best thing for them. So definitely always you want that will, power of attorney, medical directive. Sometimes in some cases a trust is appropriate and would be the best thing for the client. So those are your basic kind of estate planning documents, and really everybody should have them.
Do you find people just kind of like throw their hands up and they're like, this is too complicated, I don't even want to start it? And we talked earlier about the sense of urgency in getting this done. Do you feel people are just so intimidated by it, they don't even know where to start?
I can't get people to fill out my questionnaire. So if I get so excited when they call. I'm glad that you called me. I want to help you. That's the first step, right? You call my office and you say, I need to see an attorney. I want to talk about estate planning. But yes, it does get intimidating, right? Because now you have to fill out this 9-page questionnaire, and we're asking all these questions, and we're asking about finances, and we're asking about your kids and your grandkids and your pets. We do pet trusts. We ask about your pets, right? So I think, and it is very overwhelming. It is, all serious aside, I know I'm making jokes. I'm trying to make light of the subject, but I do feel bad for the clients. I do. It is a lot, and it is a commitment of time and energy to sit and think about these things. But I do encourage everyone to take the time to do it, because without it, things can become really messy for the people that you care about, right? Because that's who you're leaving the mess with. If something happens to me tomorrow, it's the good old if I get hit by a bus situation, right? So if I get hit by a bus tomorrow and I don't have an estate plan, it's my family that suffers, because they're the ones that's going to be scrambling. They're the ones that's not going to know what to do or where to go or how to do anything or whatever. So it's important. And I actually like to use myself as a example of how a simple, I guess this is another myth, right? That we make presumptions. We all think we know, right? But we don't always know. So if I were to die tomorrow without a will, I have a unique situation. I have a spouse. I have a living parent. I have no children. So I think a common presumption would be, well, everything goes to my spouse. That's not accurate. So if I die without a will, that's called dying intestate, and the laws of the state of New Jersey govern how your estate is divided if you die without a will. So a portion of my estate actually goes to my spouse, but a portion of my estate actually goes to my mother. Now, I love my mother. I'm sure she would do the right thing by my spouse, but again, not everybody has those dynamics, right? I could not have a good relationship with my mother. My mother could have a terrible relationship with my husband. And if I want to avoid that, the burden is on me to make sure that I craft a will that is in line with what my wishes are. And so we can't make presumptions. We can't assume we know if we don't know. And it's just really important to make sure that these things get done, even though I sympathize. I know it's difficult, and I know it's time consuming, and it takes a lot of energy to talk about things that are not pleasant, but it's really important.
Yeah, no, I totally agree, Kim. It is something that we have really stressed to our clients, because we're also on the other end when people can't change their insurance, or when they're trying to sign up for government documents, or they're trying to pay medical bills and they just can't because, like you said, they don't have the POA in place. They don't have the medical directive. It becomes very scary when you're working retroactively instead of proactively.
Sure.
So yeah, one more question for you, then we'll let you go. Something we talked about briefly on the last time we had you on was this massive appeals court ruling, I believe you said, about 55 and up communities, and how the township of Berkeley, where we're based out of, sued to have property ownership in 55 and up communities only for people 55 and up. That was viewed as something that was discriminatory. It seems the appeals court has shut that down, and now people under 55 can own properties in 55 and up communities with a couple stipulations. Can you talk a little bit about that so people in New Jersey can understand what's happening? Because I do feel like there's been a lot of misinformation about this case out there.
Essentially what the appellate division, ruled was that, it sort of like deprives you of your right to own property. And it really, I think I was really impressed by the decision, because they were able to look beyond what was in front of them, right? And what the court really kind of looked at is, and when I say beyond, I mean estate planning. And they did actually address that in the decision. It's a simple concept. You might have a parent, so I'm 51 and my mom is 75, right? So if my mom owned a home in a 55 and over community and then passed away, and it was supposed to go to me, a law like that would restrict me from owning the home. Or if my mom wanted to put me on the deed for estate planning purposes, for whatever reason that might be, I wouldn't be able to own the house because of my age. I'm not 55. So I think that, there's this balance between, we obviously want to preserve housing for seniors. And, we understand, I think we can all agree, having 55 and over communities is really good for, our aging population, because it gives them a space where they can, they have a different lifestyle than somebody who's young with younger children. And so we want to be able to preserve that for, our aging population. However, when you have restrictions like that, that causes sort of a butterfly effect. And whether it was intentional or unintentional, certainly I can't speak to that. But I think the court sort of identified some of these other problems that were coming as a result of that. And something as simple as estate planning was one of those things. And so we don't have to worry about that. The appellate division upheld the trial court, which basically said that, you couldn't restrict that ownership. And I think it was a really good decision for someone sitting in my shoes. From my perspective, I think it was a really good decision for that reason.
Yeah, no, it's great. It's one of those things where at first you say maybe it's not the best decision. Then, like you say, when you explain the butterfly effect and the chain of events that could lead to something like this, it does become a little more clear why the court decided what they did. Well, Kim, we really appreciate your time, your expertise, everything you offer, as always. If people want to work with you, if people want to fill out your questionnaire, make sure everything is all set up. How can they reach out to you and make sure that their future and their family's future is protected?
Sure. Please feel free to go to our website. If you just Google Timothy Rice, Estate and Elder Law, you'll find us. And we have a lot of resources online. We have videos, blog posts, checklists, all kinds of free information, which I certainly encourage my clients to look at those things even before you meet with me, because it'll give you a really good idea of it's sort of preparing yourself for what we're to discuss. And I've gotten a lot of great feedback on it. I've had people schedule an appointment with me and say, I watched your video on Medicaid and you explained everything so great. And, it was really helpful to kind of understand those things. You can call the office at our toll-free line, which is 833-888-0462. And again, you can also email me directly if you'd like to. It's kfiero@timriceelderlaw.com. My email is available on the website as well. So I would encourage people to visit the website, and all the information is there.
Awesome, Kim. Well, yeah, we always appreciate your insight, your bubbly attitude for what is such a, serious thing, but you bring a lot of joy to it, and it's really cool to see. So thanks, and we'll see you on the next time.
Thank you so much for having me. I appreciate it. Thank you.